Hello, welcome back, everybody. We're into Module 4, Chapter 4. We're finally getting into the non-statutory labor exemption. So before we get to the updates, we'll be teaching this in class. We just want to point your attention to page 119 and following the antitrust overview that leads into the non-statutory labor exemptions application to, of course, the NFL and the NBA, not the MLB, because it has its antitrust exemption of its own, as we've just learned in Module 3, Chapter 3. So do take a look just real quickly at, the antitrust overview at page 119, page 120, per se unlawful versus rule of reason analysis at page 131, rule of reason balancing at page 122, 121, 122, and then section 2 monopolization, which we see very little of, and then antitrust law in sports, at page 123 and 124. And that gets us right to where we want to be, the statutory framework for the statutory and non-statutory labor exemption. That picks up most specifically at page 129. And what we want to focus on today is, as we look back at our assignment for Module 3, we want to look at the imposition, the unilateral imposition by the employer at the expiration of the CBA at impasse, which is the Tony Brown case. So that being said, Ellie is here and Professor Caputo is here. Thank you so much. And we put together these update links. Mike McCann will be with us in week 5, but his Sportico article, Ellie gives us a lot to talk about, and reading ahead to American Needle and Fraser, which are later on in the book, but still going to be important parts of our discussion. Single entity in esports, the esports JSOL article we'll be looking at that Aaron helped me write also speaks at some length about the single entity structure. That would be at page 230. Following single entity is at page 228. American Needle is at 229. Single entity is at 230 and 231. So that being said, we've prepared this. We've actually prepared it, Ellie and Aaron. So how does the MLS force majeure clause invocation possibly have a different outcome than it would in the NFL or the NBA, because it's a single entity, Ellie? Is that what we're talking about here?
Yeah, so one thing to understand about the MLS is that it occupies a unique space within the legal framework of sports leagues. How we typically think of a sports league is you have 30 or 32 teams, all individually owned by various owners. And so, we understand it's the NFL, the NBA, and the MLB. And we've built up an entire legal framework around that we understand, that's in the textbook. The MLS is outside of that framework because it's structured as what's called a single entity. Essentially, it's one company. So everything is centrally owned at league headquarters, as opposed to dispersed, out and among 30 or 32 or however many teams by separate owners. So because you have this centralized control at league headquarters, the courts don't need to engage in antitrust analysis, in thinking through, do we have collusion among teams? Do we have, I think the exact language of the Sherman Act is a contract in restraint of trade. The MLS doesn't have to deal with that. And so the rules that govern the MLS and their labor process are a little bit different, and therefore not really as applicable to the leagues that we normally study in this course.
Thanks. You can't conspire with yourself, Professor Caputo, right? That's when we wrote the esports article together. The publisher really is that single entity in the NBA 2K. You could say the same sort of single entity analysis. We'll go through that article with the class, but this whole idea of the non-statutory labor exemption only kicks in when you have labor negotiation among and between management, ownership, management council, NFL, and the Players Association. And when you don't have that, when you have a single entity or a publisher of NBA 2K, even though you could separate that out and say, well, wait a minute, no, the NBA teams themselves through the NBA 2K, they individually own the teams, but the publisher maybe is that single entity. Do you want to tease that out? It's not on the script, but it's something that we'll be looking at in week 4. Aaron? Professor Caputo?
Apologies, I was muted.
Sorry, that's muted. Okay, fire away.
Yeah, no, sorry, I just wanted to touch on one quick thing on MLS really quick too. And actually this does tie into to one of the points in the article that we made about publisher and team relations is that MLS has always claimed to be single entity. I don't know if you do a full analysis in present day, not 100% sure that comes out the same way, considering the clubs are competing businesses. Again, it's pretty widely accepted, universally held that the MLS is single entity, but on deeper review, it may come back where you see that there are potential teams competing against each other for certain businesses. Maybe it isn't a single entity at this point in time. Again, I don't want you guys to hold on to that, but I'm just saying, if you look at it, it may come out substance over form. It's more of it's possible that it is not a single entity once you look deeper into the business operations and business practices of the league and the teams themselves. And then take it over to esports, and we're talking about the NBA 2K League. Similar structure there, where it's a joint venture between Take-Two Interactive, the publisher, and the NBA. And then, excuse me, all the teams are owned by the individual NBA teams as affiliates, and so we get to the same point where is it single entity? Is it not single entity? And Press Carfagna and another colleague of mine, Kyle, and I dive in a little bit more into that in that paper, and so yeah, we can talk a little bit more in detail there.
I think on the other side of the coin, we had Chris Dubert last year when he was general counsel of DC United speak to, but all MLS players are employed by the league. So that's the counterpoint to the single entity, right? The contract is a standard uniform contract, and the league decides which players go to which team. So that's two sides of the same coin, depending on how you look at it. But just on the vaccines, we had Jeff Patch talk about this. We're going to be getting into Tony Brown, the ultimate Supreme Court case, which as this says, page 136 and following. We talked about the non-statutory labor exemption. And Ellie, again, maybe, and Mike McCann, who will be with us in week 5, maybe Professor McCann, makes the point that even if there were a negotiated agreement that got outside, or stayed within the non-statutory labor exemption, it could not get outside of certain privacy laws. So this is a very provocative point that Mike is making, and we're going to talk to the class about it. But what is your first take on this item?
Yeah, I thought this was quite interesting because we normally, I think, understand that the non-statutory labor exemption will cover. This is a generic back and forth between labor and management. The NFL really, really, really wants the players to be vaccinated. They've decided to proceed not as a mandate, but as, effectively saying, if you don't get vaccinated and there is a COVID outbreak, it's going to be horrible for your team. Everything from fines to the potential for forfeiting games, which, again, in a 16-game season, you don't want to be forfeiting any games. And so, again, the Brown v. Pro Football Inc. told us a while ago, channel this into labor law. Bring a labor suit, negotiate a collective bargaining agreement, or sue under that collective bargaining agreement, or resolve your dispute through the labor processes. But McCann makes a point that I think is interesting, that when you have a separate federal statutory scheme, in this case, HIPAA and the health data privacy laws, with protections in the workplace, that might actually come to either preempt or overcome this general presumption that we don't do antitrust suits here. So, the causes of action would have to get figured out. And, I'm sure that the PA's lawyers are looking into this. But if that's the case, right, if the court were willing to chip away at the non-statutory labor exemption and carve out, certain federal certain areas where we have federal statutory schemes, right? This would not just be limited to data privacy laws. You might have, we have workplace safety laws. Does that get imported into a chipping away of the exemption? I don't know the answer to that question, but I thought it was incredibly interesting.
I think we also have to read ahead to the StarCaps litigation, which is the only other precedent that's at page 179 and following. And, let's not forget about Section 301 of the Labor Management Relations Act, right? Mm-hmm. That basically says everything stays within binding arbitration, as Jeff Bash visited. So, but in that case, what escaped preemption by Section 301. This is a different kind of preemption. This is a preemption that says we're not going to fool around with state common law claims. We're going to allow, the labor courts to determine anything that happens relative to two parties in a collective bargaining relationship. But in that case, the two things that escaped were state statutes. So we'll read ahead into that. We're not meaning this to be provocative and predictive of where we're going, and thoughtful about where things might portend as we go into the future, as we go through Chapter 4 and tease the edges of the non-statutory exemption. And one last link before we leave you, and a couple here on J-cell. Professor Balsam suggests that Alston, the famous case on amateurism, which recently came down to Supreme Court, and Justice Kavanaugh's famous dissent in which he said, the NCAA is not above the law, the antitrust law. This rule of reason that we look at the beginning of Chapter 4, again, is taking a deep dive. There's even antitrust flow charts, if that helps. That's at page 257 and following. But Jody, who's a good friend of our program, has been here many times, makes the good point that after Alston, which went into professional sports, even though it didn't need to, did talk about softening perhaps of the rule of reason if and when any competitive behavior were to be looked at on an antitrust basis. Ellie?
That's right. And we were incredibly excited this year for JSL to publish a special online issue on the Alston case. Professor Balsam was kind enough to contribute one of the essays in which she looked at, the Alston decision, which effectively was a decision about college athletics and the NCAA and the applicability of the rule of reason to what the NCAA does. She takes the broader view that the court made some statements about the way that we do the rule of reason in sports that, if you're the NCAA sitting there after that case, you're probably not too happy. But if you're the NFL or the NBA or maybe to a lesser extent Major League Baseball, because I think with MLB, they raised the possibility that MLB's antitrust exemption, maybe the hour may be late on that. But the rule of reason now, as pertains to professional sports in the antitrust context, seems to take a much more forgiving view of what sports need to do to keep their businesses going and to operate leagues the way that I think we've become quite familiar with them operating. So I think Justice Gorsuch had the opinion for a unanimous court in Alston. And so it signals that, between that and another recent case, you had American Express v. Ohio, I think, that the court is just becoming more and more permissive on antitrust. And so, absent a statutory change or, assertion of jurisdiction and a kind of more aggressive posture by the FTC or the Justice Department, which is entirely possible. It looks like antitrust right now for professional sports leagues is moving in the direction of, you can more or less do what you'd like.
And we'll hammer that point home by going to the assignment. Thank you, Ellie. Really, the summary of Brown at 136, 137, 138 basically says between Justice Stevens' majority and then Justice Breyer and Justice Stevens, we give you the summary of both of those and the implicit exemption, he calls it, reading at the bottom of 137, recognize to give legal effect to the general labor laws and policies and to allow meaningful collective bargaining to take place, then restraints on competition imposed through the bargaining process must be shielded from antitrust scrutiny. And this is the answer to the imposition, the unilateral best and final offer that we put into the assignment that's now pending, right? And there are the four conditions to the imposition, the unilateral imposition of a best and final offer. And then the dissent, as I said, from Justice Stevens is summarized on page 138. So that's a quick look at updates and looking forward, looking back at Chapter 4, including a little look at esports, which we plugged in here to show the difference between being a trade association and a union at the bargaining table. And I think we're going to keep coming back to that when we look at the decertification efforts. Freeman McNeil, can a union decertify and therefore have antitrust standing? we'll see that it did work in the Freeman McNeil case, and it did not in the Brady NFLPA decertification case. The end run that McNeil succeeded in failed, and that's at page 139. So a quick summary of chapter 4. Looking back, looking forward. Thanks, Ellie. Thanks, Aaron. And look back at the antitrust exemption, and good luck on the assignment.